I think it's time we can begin. There's still some people filtering in, but they will not disturb us. Well, welcome to the second panel discussion of the day. We're going to turn our attention to some contemporary issues that have called into question, at least in some quarters, some of the teachings that we inherited from Judge Bork, and particularly with relevance to the ultimate goals for which this enterprise is designed and used. We're going to hear from four speakers. I'm going to, Dean, do they have bios? Does everyone here have a bio of the, they don't? Well, I'm going to give you a very abbreviated bio. I can assure you that all three of these people have law degrees. Diana Moss is a PhD economist, but a little bit more than that. Josh Wright, to my immediate left, is my colleague at George Mason Scalia Law School and is director of the Global Antitrust Institute. He was a member of the Federal Trade Commission a few years ago. And this is the order in which we will hear from them. Diana Moss is the president of the American Antitrust Institute here in Washington and a member of the faculty of the University of Colorado Economics Department. And Deb Garza, from whom we'll hear third, is a partner at Covington and Burling and co-chair of their antitrust and competition law practice group. She was a member of the Antitrust Modernization Committee, as you know, was Macon Del Rahim, who spoke this morning, and she's going to recall some of the ways in which current themes today are really repeating things from the past. Noah Phillips is a recently confirmed, I should say, member of the Federal Trade Commission, having come from the Senate where he worked for Senator Cornyn. I think that's all you need to know in order to proceed. Josh, will you get us started?
I will do my best to get us started. I think the goal of the panel is sort of to tee up some of the modern debates, and so I'll spend a couple of minutes putting the modern debates in a little bit of context, although we spent some time doing that this morning as well. But I really want to spend most of my time highlighting a couple of the key claims and challenges to the modern antitrust consensus around the consumer welfare standard. Judge Bork in Antitrust Paradox, I brought it all the way here so I could wave it around as a prop, so here you go. In Antitrust Paradox said, is the antitrust judge to be guided by one value or several? If by several, how is he to decide cases where a conflict in values arises? Only when the issues of goals has been settled is it possible to frame a coherent body of substantive rules. At the time of writing the Paradox, it was Judge Bork's view, and I think he makes a persuasive case throughout the book, that antitrust doctrine at the time wasn't intellectually or otherwise coherent. And so the main contribution, I think in terms of long-lasting effect on antitrust doctrine as a whole, is injecting the consumer welfare standard as the lodestar of the modern antitrust enterprise. That leads to lots of adoption of different nuanced standards for vertical mergers, horizontal mergers, whatever else. But at the 30,000-foot level, introducing consumer welfare as the lodestar of modern antitrust is really the linchpin of all of sort of the modern intellectual foundation of antitrust. An antitrust system with consumer welfare as its lodestar has myriad benefits. It tethers, importantly, antitrust law to economic analysis. By cabining discretion for agencies, it reduces risk of rent-seeking or antitrust policy used to pick winners and losers. In large part, I think if you were to ask antitrust practitioners, economists, scholars of sort of within either the academy or the courts or the agencies, if the introduction of the consumer welfare standard has been a success relative to the state of antitrust law prior to the Antitrust Paradox, I think you would get a resounding and overwhelmingly in consensus yes as the answer to that question, sort of across the board. Interestingly, we do need something to debate. And so the debate won't come from within the antitrust community, although we can find things to debate over within the consumer welfare standard. Do I think there ought to be more or less enforcement of this kind of merger, or a debate over evidence? And we can have those debates too. But the consumer welfare challenge has come largely from outside. Some refer to themselves as new Brandeisians. I think I referred to them as being hipster antitrust and got myself in a little bit of trouble for that. But choose the term that you like, but it's an important challenge to the modern antitrust enterprise. And really the challenge is not about quibbles over how to apply the consumer welfare standard, but rather is really about, one, re-injecting socioeconomic goals into the antitrust enterprise. Let's balance welfare against jobs or inequality, or pick another socioeconomic value of your choosing, and ask courts and agencies to maximize across objectives. It would also, these various proposals to either dilute or divorce antitrust from the consumer welfare standard, also envision a much a reduced role for economics in the development and shaping of antitrust. I want to highlight a couple of the main themes of that debate, talk a little bit about the evidence, and then I'll sort of leave the rest of the discussion for the panelists and later in the discussion. The very first claim is that corporate concentration is increasing massively in the U.S. economy. The second is that that's a bad thing for consumers. And then the third is that all of that is happening because the antitrust agencies are asleep behind the wheel. Those are sort of the three main claims, and I'll talk a little bit about some of the evidence underlying or missing in each of those debates. At a very high level, the claim that corporate concentration is increasing, the most commonly cited sources for that information, there's a paper by Jason Furman and Orszag. Jason Furman was chief economist in the Obama administration's Council of Economic Advisors, very, very good economist. And they put together a paper that at two-digit and later at four really broad industry classification levels. So in antitrust, we often, when we do market definition, it will be, what was the market definition in Staples Office Depot? The sale of consumable office supplies through office superstores. This is more like stuff made with metal. This is the level of aggregation. It's not quite antitrust markets. And they'll point to these and say there's been a little bit of an increase over time, right? They'll calculate something called the C50. C50 is you take one of those big industry classifications, you add up the shares of the top 50 firms, and you count with your fingers what the shares are, or you get some friends and count with your fingers. And at the end, they say those shares have gone up a little bit over time. In large part, I think that the response to those data have been, from the antitrust community, has been a little bit of indifference, because the antitrust lessons of the 60s and 70s were largely exactly on this point. Aggregating up markets to industry level obfuscates what happens in markets, and in antitrust, it turns out what we care about is what happens in markets. Another response has been, maybe if you can count a C50, and it means there are 50 firms. One of the statistics in the Furman and Orszag paper is the C50 is over 30 in more industries than it used to be. So you can do the math in your head. That means the average share is 0.6%. If you would like to lose sleep over the average share of 50 firms in an industry being 0.6%, I will not stop you. But you can imagine the response of most sort of inside the antitrust community being something like, if you can count a C50, maybe you don't have a concentration problem. There have been other empirical parts of this debate. I won't go through them in significant detail. I will say that I think much of this debate has focused on smaller issues like, do we have particular problems with common ownership being an example, and one which Commissioner Phillips recently gave a speech, or vertical mergers in particular, or trying to trace whether U.S. merger policy is in the right place, largely through merger retrospectives, studying individual mergers. For one, even though perhaps you can tell by sort of my tone as I read through the evidence, I'm not of the view that any of the three fundamental claims of the critics of the consumer welfare standard have been substantiated or frankly, even close. As an economist, I'm pleased we're having the debates. Antitrust institutions evaluating themselves, the body of law. We have empirical tools and data available to do self-assessment we didn't have at the time the book was written. So it's a debate I think that it is important to have, but one I think where thus far the evidence in favor of rejecting the consumer welfare standard or dramatically changing modern antitrust as opposed to tinkering around the edges in a variety of areas in response to evidence. That case has not been made, and to the extent it's attempted to be made, the attempts have been somewhat underwhelming. I will stop there.
Thank you, Josh.
Thank you, Judge Ginsburg, and thanks to the Federalist Society for inviting me here today. It's a pleasure to be here. I just want to make 3 opening remarks, and then I'm sure we'll have follow-on discussion about each of them and their implications. One is, and some of this will dovetail with some of what Josh has said, but I want to talk about the context around the debate, the current debate over competition. I call it climate change around antitrust enforcement and competition policy. And then I want to talk about the adequacy of the consumer welfare standard as part of an invigorated enforcement regime. And then I want to talk about sort of using the standard and the laws to push them to their full scope to take on what I think are pretty serious challenges ahead on the competition front. So first, context for the debate. As Josh was noting, I mean, there is a big debate over competition in the U.S. economy and in the global economy and local economies. There are concerns that have popped up that are backed up by empirical evidence that we are seeing higher levels of concentration in using fairly aggregate measures of concentration. We're seeing a slowing in the rates of startups. In fact, startups are in a 30-year decline, and we're seeing growing inequality gaps. So we think we might have a competition problem. And the question is, well, what's the appropriate role of antitrust in solving that? I would note that the labor economists and the macroeconomists are on fire. They are doing empirical study after empirical study, absolutely showing that higher levels of corporate concentration are linked to lower wages, to slowing rates of innovation, and to higher markups. So that literature is out there, and it's a well-vetted literature. But here's what's missing, and this is the question that everyone, that should be answered, and this should be part of an agenda, for example, the FTC's agenda in their upcoming roundtables, and that is to establish what is the cause of higher levels of corporate concentration. Is it natural economic factors like scale economies and scope economies even, or network effects, or is it a result of lax enforcement? That is a question that has not yet been answered, and it is a question that badly needs to be answered so that we can understand and adjust antitrust enforcement and competition policy accordingly. So there's a lot of work for the industrial organization economists to do moving forward, and they are way behind the labor economists and the macroeconomists, but they are the only people, the only discipline that can actually ask and answer the question, what is the cause of higher levels of concentration? And I'll take Josh's points that yes, we're using aggregate measures of concentration, but that begs the question, well, what levels of concentration do we need to use? Well, we absolutely need to do the study that looks at relevant antitrust markets, for example, in sectors that have been subject to lots of consolidation, like telecom, like airlines, like healthcare, like agriculture, food and ag. We can do that. We can look at how successive merger activity has affected concentration in those markets. That is the concentration metric that is appropriate for coming to any conclusions or making any statements and developing any policies around the role of antitrust in addressing declining competition. All right, so this is all troubling. I think we would all agree, regardless of viewpoint or ideology, that we like our markets and we like our market-based economy. And those markets don't take care of themselves all the time. And we need antitrust enforcers in there as a referee to make sure that the game is being played on a level playing field. And so we've seen an uptick in enforcement, for sure. Under the late Obama era, Enforcement agencies, we saw big mergers being challenged successfully, the health insurance mergers. We saw Baker Hughes Halliburton fall apart. We've seen Cisco US Foods. We saw Staples Office Depot. I mean, the list goes on. And we just saw the Department of Justice challenge the AT&T Time Warner merger. Not a great outcome for the government, but the story is not over yet, would be my prediction. All right, number 2, adequacy of the consumer welfare standard. Well, the reason why we're having this debate is because the spectrum around the ideology supporting antitrust is stretched. It used to be the conservative ideology, and it used to be the progressive ideology. Well, we now have a new entrant, as Josh pointed out, on the spectrum, which is sort of the far left. Call them hipsters, call them neo-populists, call them what you want. It has shifted and rearranged the spectrum of voices on this continuum. So the progressives are really sort of solidly in the middle, advocating for the durability of the law, the antitrust laws, and the adequacy of the consumer welfare standard. And the view there is that the standard is quite capable of taking on all of these challenges that we face. It can address price effects. It can address non-price effects like quality issues. We've seen that in hospital mergers. Innovation effects. We've seen that in cases like Applied Materials Tokyo Electron. It even popped up in Dow DuPont. It can take on innovation issues. It can take on choice issues. So the standard is flexible, and it is capable of dealing with these challenges that we face. This stands in stark contrast, right, this middle spectrum viewpoint to the newer voices on the left that say, well, we need to throw out the standard and adopt a public interest standard because we want to get to things like employment effects, perhaps even environmental concerns, broader socioeconomic issues. Whereas just to contextualize it, the more conservative voices would argue for a fairly narrow reading of the consumer standard as only going to price effects and even pushing into what I call as an economist, what we call a total welfare standard as opposed to just a consumer welfare standard. So that's kind of how things are sort of breaking out amongst the different voices and ideologies. We think there's good evidence and ongoing support for the flexibility of the standard, not only in merger enforcement, but in Section 2 enforcement, taking on issues, say, relating to the digital platforms, taking on issues relating to a buyer power, for example, monopsonistic behavior or oligopsonistic behavior. We've seen an advancement in looking at agreements, for example, the no poach and wage fixing issues that are popping up more and more and more. So the standard's there. It just needs to be used. So moving forward, there should be high priority items like the intersection of intellectual property and competition law. Distribution, I guarantee, will be a bigger and bigger issue. We've seen it in beer. We're now seeing it in a variety of other mergers. Buyer power issues are front and center. AAI did our conference yesterday and had much to say about buyer power, and certainly the application of the laws to the digital platforms. But it is going to take some aggressive enforcement. It's going to take some expansive thinking about the use of the standard and what it can reach to. And we shall see. Eyes are peeled for the new leaders, the new leadership at the Commission, the Federal Trade Commission, and at the DOJ. And we will see how that evolves moving forward.
Thank you, Diana. Deb?
So I think it's a testament to the power of Judge Bork's work and the work of others associated with the Chicago School, how little significant difference there really is between the views of the panelists probably this afternoon and this morning. In the 15 years between 1978, when the book was first published, and 1993, when it was republished, and when Judge Bork published a new introduction to the book titled The Passing of the Crisis, antitrust enforcement had moved to a place of intellectual respectability, both as to law and economics. But Judge Bork also said in 1993 that areas of improvement remain, and predicted that the debate on antitrust would continue, and indeed he was certainly right, because we are still obviously debating it today, and there are areas for improvement, some of which I think were talked about in this morning's panel. Periodically, we have chosen to review the state of U.S. antitrust law policy and enforcement in order to ensure its continued soundness. We've asked, do we have the right objectives? Is it the consumer welfare standard, and what do we mean by the consumer welfare standard? Do we mean consumer surplus, or are we really talking about a total welfare standard? That issue has been debated really for the last 40 years, and we still don't have a consensus on that. And I hope that that will be something that the FTC and the DOJ will tackle as they are pursuing their efforts to examine and re-examine policies. Are we making the right enforcement decisions in the right way? Are our premises correct? One that I think is important is, do we know enough about the effect of concentration on innovation and dynamic competition to continue to base our enforcement decisions on presumptions or measures of concentration? And is there really evidence that markets have become too concentrated? Even if you accept that in certain industries they have become more concentrated, have they become too concentrated? And that goes to what Josh and Diana were saying about concentration. And we've had to extend the debate to antitrust enforcement globally. That affects performance in markets, affecting U.S. consumers and global economic welfare. A bad policy in China undermining the protection of IP rights doesn't just affect Chinese consumers. So though this is a panel on the current and future state of antitrust, I wanted to take a short flashback to the 2007 report and recommendations of the Antitrust Modernization Commission, of which I was the chair, which seems appropriate for today for two reasons. First is that one of the commissioners on the AMC, Makan Delrahim, is now the Assistant Attorney General for the Antitrust Division. And a second, Don Kempf, is the Deputy Assistant Attorney General. It appears to me that they are seizing the opportunity of the leadership of the Antitrust Division to pursue some of the things that the AMC recommended and to pursue Makin's own views expressed in his separate statement to the Commission reports on intellectual property. Second, yesterday the FTC, as I think Noah will discuss, has conveniently for this panel just announced a wide-ranging series of hearings that is probably the most comprehensive review of antitrust law and policy since the AMC report in 2007. So just for those of you who, and I also want to give a shout out to one of my other AMC commissioners, Steve Cannon, who's in the room. And for those of you who aren't familiar with what the AMC was or why it existed, it was created by Congress to make a comprehensive review of U.S. antitrust law to determine whether it should be modernized. The statute was enacted in 2003, so it's been a while now. My hair wasn't white at the time. But the AMC Act was motivated in part by recognition that competition in the 21st century has increasingly involved innovation, globally integrated trade, and networked industries, what we called at the time the new economy. And that sound antitrust enforcement required a proper understanding of how these forces affect competition. Big data was not an issue at the time, but it was those kinds of issues that propelled Congress to create the AMC. So the report was issued about 10 years ago. The AMC was a bipartisan group of 12 experts appointed by both sides of the aisle in Congress, who came to the project with diverse and strongly held views, but found consensus on 80 recommendations, mostly unanimous consensus. So I want to just highlight 4 sets of those recommendations that I think are particularly relevant today. One is immunities and exemptions. The AMC identified 30 statutory immunities from the antitrust laws. We observed that while Congress certainly has the right and is entitled to make judgments about the extent to which it is appropriate to displace competition to serve other important societal goals, antitrust exemptions impose costs and are inconsistent with the fundamental economic policy favoring free market competition as the mechanism that we've chosen to funnel scarce resources to their highest value. We recommended a framework for evaluating the need for immunities. We hired Greg Leonard, Darren Bush, and Steve Ross to help us out in developing the framework, and we held hearings on certain exemptions. We earned praise from Congress for our approach, but I can't say that we had any real-world impact. So keeping the flame alive, in March of this year, DOJ held a roundtable on antitrust exemptions and immunity and on the role of regulation, of industry regulation and antitrust. So presumably we'll see a report at some point, and perhaps amicus briefs in matters involving the application of implied and statutory immunities. And I think that's a good thing. I'm happy to see that. Diana, I think, participated in that roundtable, so she may have more to say about that. Another area where the AMC, not unanimously, made recommendations was in the area of indirect purchaser litigation. 9 commissioners, including Macon Delrahim and Don Kempf, recommended that direct and indirect purchaser litigation would be more efficient and fair if it occurred in a single federal court proceeding that avoided duplicative recoveries and also ensured recovery to all injured persons. To facilitate this, the majority of the AMC commissioners recommended overruling Illinois Brick and Hanover Shoe. Commissioners Cannon and Dennis Carlton and myself did not happen to join in that recommendation. At the beginning of this year, Macon and Andrew Finch, who was on the first panel, said in public remarks that DOJ was considering whether to urge the Supreme Court to overturn Illinois Brick and Hanover Shoe. In March, however, DOJ filed an amicus brief urging the Supreme Court not to do that in the Apple versus Pepper case, which presented a question of whether you and I could sue Apple for overcharging commissions to app developers. So the Ninth Circuit said yes, and now it's up to the Supreme Court to decide. So that's another issue that I think that we'll see some kind of decision on. And another area that we talked about was substantive merger enforcement, which was discussed in the first panel here today. The AMC said a lot about efficiencies and how they should be looked at. We also recommended further study of the economic foundations for merger enforcement policy, including the relationship between concentration and other market characteristics and market performance. And we asked that we recommended that the agencies update the merger guidelines to explain the approach to vertical mergers. We know now from hints that have been dropped by Macon and other officials at the Antitrust Division that the division is in fact considering issuing vertical merger guidelines. And of course the FTC has announced that it tends to hold these hearings on a wide range of topics, including on merger enforcement. And then finally, IP. In the area of IP, while recognizing the importance of innovation, the AMC's report recommendations in the area of IP largely focused on aspects of the patent system that impact competition, playing off what was then a recent FTC report on that. Commissioners Delrahim and Kemp did not join in those recommendations because they disagreed with some of them. Importantly, I recommend that you go and look at Macon Delrahim's separate statement to the report because he in particular disagreed with one of the recommendations of the AMC, which was to treat the joint negotiation with IP owners by members of a standard-setting organization under the rule of reason rather than as a buyer cartel. Commissioner Delrahim did not join in that recommendation for the reasons that he's articulated more recently, which is his concern that it didn't balance correctly and it didn't protect adequately the rights of the innovators and balance correctly the rights of the innovators and implementers. And since he's been taken over the head of the agency, in fact, he and others have made speeches warning that DOJ would be skeptical of SSO rules that appeared to shift the bargaining leverage from IP creators to implementers. We understand that the Justice Department is investigating some SSO practices. And I also recommend in that regard that you read Macon's March 16 New Madison speech. So I think there's been a shift in the way that the department is looking at intellectual property / antitrust issues, and a shift toward stronger protection for innovators.
Commissioner?
Thank you. Thank you, Your Honor. Third time's a charm. Thank you, Your Honor. Let me just begin by saying how excited I am to be here with all of you and at the Federalist Society in particular. I can't think of an organization that does more good work to foster the important intellectual debate that you all do about the law and its application. And I have to give the sort of caveat that they require you to give, which is the remarks I make today are my own remarks, not necessarily representative of the views of the FTC. As you've heard from a number of the other panelists, and as you may have seen in the news, yesterday, Chairman Joe Simons announced a very ambitious initiative to conduct hearings over the course of several months, quite a few hearings, on a wide variety of topics in antitrust and consumer protection law today. What I want to do for the benefit of the audience is just sort of read through the topics where we've asked the public to submit ideas on what we should talk about. So the first is the state of antitrust and consumer protection law and enforcement over the last 20 years. That is roughly the time period since a similar group of hearings were conducted by the FTC under the chairmanship of Robert Pototsky. The second topic is competition and consumer protection issues in communication, information, and media technology networks. Market power, entry barriers, and competitive behaviors in platform markets. The intersection between privacy, big data, and competition. The competitive effects of corporate M&A, writ large. Evidence and analysis of monopsony power, including but not limited to in labor markets, the role of IP and competition policy in promoting innovation, and the interpretation and harmonization of state and federal statutes and regulations that prohibit unfair and deceptive acts and practices. We're here talking about antitrust and the very important legacy of Judge Bork, but of course at the FTC, we do quite a bit of consumer protection as well. If what I've just described to you sounds like pretty much everything, that's correct. This is, as I said before, an ambitious project, and we're very much looking forward to going around the country, literally, and hearing from all sorts of folks with their views on all the very many issues we deal with today. I don't know that we will answer every question. I doubt we will. But I hope we will ask all of the questions. And I do hope that, like what followed from the Pototsky hearings decades ago, we will gain a lot of knowledge about the direction we ought to take. I think this is a very important project. I think it is, I'm going to borrow from antitrust law here for those of you who get what I'm saying. It is a project meet for the case. The case here being a wide assault on a lot of the things that we have long taken for granted in antitrust law. And it's an important project that will help educate us as enforcers, educate internationally, and also educate the American public. There is a lot of talk today about antitrust law, certainly as much talk as I can remember in my lifetime. And with that in mind, one of the things, or the thing I want to talk about today, other than previewing this really important effort for all of you, is to talk about Judge Bork and how he impacted the conversation on antitrust, and my personal expectations and hopes for how the conversation to follow will go, including some of my disappointment with how some of the conversation has gone thus far. Judge Bork had as rich a legacy as anyone can have. He, not alone, but with some of the other great lights, brought together brilliant scholars and jurists and economists and practitioners, and together came up with the way that we do antitrust law, and the way is a good one. He introduced, among other things, a common language. That language drew heavily on economics, which is part of why we're spending so much time today talking about economics. Relatedly, he brought intellectual rigor to the law. That's a very important thing. I want to dwell on that for a minute and talk about rigor and language and how they relate. One of the things that I've observed in some of the present conversation is using words in a way that don't add clarity to the conversation. And I'll take as an example the word monopoly. Everybody knows, or everybody knew what monopoly meant, but I have observed in the last couple of years people using monopoly to describe a series of companies, a series of trends, a series of deals that may reflect monopoly or may look a lot like monopoly, like a duopoly, but may also reflect just something they don't like. So it's almost every big high-profile deal that is met with the word monopoly. And you see editorials that say we have a monopoly problem, and then they go on to describe corporate concentration. Now, there is a very important conversation to be had about corporate concentration, and we at the FTC plan to contribute to it. But it isn't necessarily a conversation always about monopoly. I have also seen writings that suggest that the word monopoly is useful because it will help inspire the public and animate voters. Those are worthy undertakings for politics. They're not terrifically instructive for a sensible conversation about antitrust policy. So I think that rigor in the approach that we take, rigor in the language that we use is very important. You've heard a lot here about the consumer welfare standard, and you're all familiar with that. I think that's a very important part of this. It is very difficult to have a conversation about what you're seeing, where you want to go, and how we ought to get there without having a common framework, again, a common language. The consumer welfare standard, notwithstanding all the disagreement that people have about what it means and how it ought to be applied, provides that framework. It allows us to speak to each other, to listen to one another, to speak civilly, and that's a very important thing. I'm reminded of the philosophical, this was a demonstration having to do with free will called Borodin's ass. So Borodin's ass is a donkey, and he is faced with two piles of straw, and he is hungry. But the piles are exactly the same, and he starves to death because he can't possibly decide between the two piles because they're indistinguishable. If we don't have a common standard, we can't answer a lot of questions. If antitrust law is a choice between truth, beauty, and consumer welfare, it may be difficult to determine what the answer is. And so it is important that we keep that in mind because the other answer may just be a mess. Justice Stewart in Vaughn's Grocery famously wrote that the sole consistency that I can find is that in litigation under Section 7, the government always wins. If that's your standard, questionable whether it is the kind of rule of law that we want. By the same token, if the big company always loses, again, query whether that is a real rule of law, and likewise with respect to a public interest standard. I can't speak for all my fellow commissioners, but I'm sure they would agree with me when I say that we are approaching this project with a very open mind. We are looking to hear from all sorts of voices across even the larger spectrum that we've outlined up here today. And I hope the discussion is a fruitful one. I do want to end on one note. I also hope it is a civil discussion. I'm almost 2 months into my tenure at the Federal Trade Commission, and one thing I can say that I've learned absolutely is that the staff there are mission-driven, they are talented, and they are smart. And unfortunately, some of the conversation one hears about the FTC, about the DOJ, under Republican and Democratic administrations, is the accusation that they are weak, or even worse, venal. I find those kinds of claims to be offensive, and I find them to be untrue. If we are going to have an important conversation about antitrust law, and that conversation absolutely is warranted, it has to be a conversation that does not include name-calling. So again, I want to turn to Dean and thank him for being part of that conversation and hosting all of us. And I'm looking forward to see where we go.
Thank you, Noah. We'll have a little crosstalk now before we open the discussion to questions from the audience. So, Josh, first, and going in the same order, is there something you want to question, query, seek clarification on, or contradict?
Almost always, Judge. I will say this is a more of an extension than a contradiction or anything else. I would say the idea that the FTC is holding these hearings and being a participant, the FTC for a long time has played a role in what that Chairman Kovacic called competition policy R&D. They've been a not just a sponsor and a platform for conversation, but an active participant in important conversations in antitrust debate. And I'm very pleased to see. It's hard to imagine from the list that Commissioner Phillips gave what topic is not covered, and so I think that is it almost has to be by design. And so I think that's precisely what an agency like the FTC, at a time when modern antitrust institutions are sort of so much under attack, it's what they should be doing, and I think should be applauded for. I would say as a sort of second small point, one place where the agency can play an especially important role. Maybe we'll end up talking about some of the empirical debate. I think, Diana and I have done the debate on the empirics probably in every state in the union. But the important thing, I think, is that the debate takes place on those terms, that the debate takes place on what the evidence is. The FTC is a place full of 50 or 60 PhD economists. It's a place where they take causal inference and real evidence seriously. And those are, the dimensions upon which the debate takes place. I will add one thing I've said. I returned from OECD meetings not too long ago, where I had given a talk saying the existing state of evidence just doesn't do it. If you're looking for claims that the agencies are sort of not in the right place in terms of merger policy, for example, the evidence isn't there, and we may disagree with that or not. But I was asked the question, well, what do we do then to produce more information? And there is one thing that I think, and I suspect will come up in these hearings and elsewhere, so I might as well throw it out now, which is I think the agencies and antitrust scholars and practitioners are especially fond of the idea of merger retrospectives. I mean, this is one place where we actually learn if an agency decision was right or wrong. Economists who have been thinking about merger retrospectives for some time have pointed out, each of those is a study with a sample size of one, and it's very hard to learn systematically if the agency is drawing the line in the right place by looking at a single retrospective or even adding them up. Economists that have been in the agencies and are prominent academics have, for a long time, and largely ignored by the agencies, called for a version of a retrospective that instead of just says, hey, you didn't challenge this one, did prices go up or down? Valuable, we should do those too. But instead, with the cooperation of the agencies, it's the agencies to write down their predictions. There are memos that come up inside the agencies where they've got economic evidence. They say, this is what we think will happen to prices. This is our model. The only way to test whether the agency's decision-making process is in the right place is to test their predictions against outcomes. Those retrospectives have never been done. They've never been done for understandable reasons. I raised this idea when I was at the FTC. I wasn't off a stage. If I was, I would have been booed off immediately inside the agency because it requires the agency to sort of share predictions, expose itself to the possibility that maybe it was wrong, share with researchers. Maybe you got to redact what the cases were or whatever. There are complications, but that is an idea that I suspect one of the really neat things that's come out of this debate is a lot of people are interested in data and evidence. You would think that comes with most debates, but that's sort of not always the case. But you've got bipartisan agreement that more study is good. Well, then let's do some studies. But think carefully about research design and that we're getting out of them what we want. And what we want isn't, Diana and I have an individual debate over one case. We don't want a merger retrospective so we can decide who buys the other one the beer. What we want is a merger retrospective or a series of studies that can inform things like, are the agencies drawing the line in the right place? Are the tools giving the right predictions? If they're not, in what areas are they failing? In what areas are they accurate? So that if we're to go somewhere, we can get a better set of directions. I think those are the sorts of ideas that not only can the agency play a role in terms of providing a platform, but for some of these ideas, we need the agency's help too.
Well, Josh, I hope the timing is right and the leadership will see it through, but I can tell you it won't be any consolation when I tell you that I tried to do that in 1985 in the Antitrust Division and got exactly the kind of pushback that you're describing here. It will take a lot of will on Joe's part and on the commissioner's part. Diana?
Yeah, just a couple of follow-up comments. This has been a really great conversation so far. I think it's worth putting it out there that we're at a juncture, I think, in the evolution of antitrust enforcement, but also what I call competition policy. Competition policy is more than antitrust. It's the whole collection of policy tools in the toolkit, regulation, for example, sector regulation, labor policy, tax policy, small business policy, all of which makes for a coherent, multi-pronged approach to tackling some of these big issues that we're all hearing about. There is a distinct risk right now with this sort of raging debate in the background, which, to be sure, is a really good and productive and healthy debate. There is a distinct risk of loading up antitrust with more than what it's designed to do. And in doing so, and you might expect that much of this is coming from the new voice on the spectrum and the neo-populists or the hipsters or whatever we want to call them, that antitrust should be the be-all and the end-all for fixing every problem that we worry about in the economy. And that is a real danger. Antitrust was designed to do certain things, to promote and protect competition, to promote consumer welfare, to promote innovation, and to support our market system. If we load it up with lots of things that it was not designed to do, we could stymie enforcement in ways that will be very damaging to our economy and to economic growth. And so I just want to put that out there because some of these problems are multi-dimensional, multi-pronged problems that really call for a more integrated competition policy approach or agenda, of which antitrust is simply one prong, an important one to be sure. I also want to point out that since this debate began a couple of years ago, the left has dialed it back. And I mean, I'm in this 24/7, monitoring, talking on panels. A lot of these people are my colleagues and friends. They have dialed it back. I mean, they came out with some very forceful positions. The consumer welfare, the laws are broken. That was one. The consumer welfare standard is wrong. We need a public interest standard instead. That's wrong. That the consumer welfare standard can only address things like price and nothing else. Well, that's wrong. And so, and I don't say this in a pejorative way, but the progressive community and the conservative community pushed back on a lot of that. And so there has been a correction in what you're hearing from that end of the spectrum. And it has created, and the only way to get that done was through this rather vigorous, oftentimes controversial dialogue. So we're getting through the process. I think, the implication is we have to support antitrust enforcement to get vigorous enforcement to protect our markets and to protect competition and consumers. And we need to, and that includes everything from appropriations to support the agencies, to participating in agency discussions, roundtables, hearings, to having good relationships with the agencies, which AAI works very, very hard on. And those are very, very important things. These are constrained agencies with tremendously talented people and resources, but they have a lot to do, and they have to make very important choices about what cases they pursue and which cases they don't. So that is, that's just some additional detail on the context, the debate that's going on, and kind of where things are going now.
Diana, let me ask you what I hope will be an easy question. You've twice used the word labor, and there was at least perhaps it was only in the early volleys from the hipsters, if you will, that there were suggestions that, for instance, the effect of a merger on employment ought to be taken into consideration, which was a factor in the Walmart acquisition of Massmart in South Africa. The tribunal on appeal ameliorated that significantly. But suppose the problem is, the facts are that the merger will not just displace some employees, but create a local monopsony. Now, that's not, in terms of consumer welfare, that's all to the good, depressing wages. But it looks like a monopoly problem, but not in a relevant product market. So what do you do? You say the consumer welfare standard is pretty capacious and or at least flexible. What do you do?
Well, so I think this is where the rubber meets the road on the different interpretations of the consumer welfare standard. And so I would respectfully, Judge Ginsburg, suggest that under the consumer welfare standard, a merger that resulted in some sort of wage depression in a labor input market would absolutely be reachable under the standard. There's nothing to prevent the agencies in a public enforcement case or private enforcement for that matter to define a relevant market around labor. And we talked about this at our conference yesterday. The Anthem Cigna Aetna Humana mergers, well, especially Anthem Cigna, the government really skates very close to making monopsony arguments, or they actually make them outright, as they did in JBS National Beef, where they defined an input market around fed cattle. Well, if you depress the price of fed cattle, most likely you're going to depress the incomes and the wages of the ranchers and the cattlemen who are bringing those fed cattle to market. So we see input markets being defined in merger cases. DOJ was very clear, saying that Anthem Cigna would spell trouble for doctors in terms of lower reimbursement rates. We haven't yet seen a merger, a case where a relevant market has been defined around labor inputs. I think that can be done. We had a robust discussion on this yesterday. There's nothing to prevent the standard from doing that. And to answer your question specifically, if there is an output effect in an input market under the consumer welfare standard, I believe that to be sufficient evidence to find for a violation.
I think in Anthem Cigna, the government's position was that it just couldn't count as an efficiency, not that it created a monopoly problem.
You're absolutely right.
Okay.
There was a very murky discussion in there that conflated monopsony power with efficiencies. And we are still all trying to understand that.
Deb?
There was one case that the Justice Department brought, a merger case involving health insurance, and I'm not remembering now which case, what it was, or where it was focused, but there was a specific allegation of monopsony effects on reimbursement to docs. And when I was there, we looked at a second transaction, I think involving a combination that affected Nevada, I think, and we again looked at the question whether there was a separate basis for challenging the transaction based on monopsony power. What we looked at was the effect on output, basically. Would the monopsony effect have an effect on output? In most cases, I don't think it's going to make a difference to your decision to challenge the transaction, but it did get looked at. I was going to say, the one thing that I think is picking up on the description what the FTC is trying to accomplish in the hearings. I think you said that it was an assault on what we have taken for granted, and I do welcome the reexamination and everything. And I see another value potentially coming of this as you're going around the country, which is communicating to people what the antitrust laws are about, because there is this confusion. And Diana says it's kind of, subsiding, but there is this confusion, I think, out there about what the goal of the antitrust laws are and whether they should be used to obtain wage equality and all these other things. It's a conversation to keep to maintain the legitimacy of antitrust rules. I do think it's important to also communicate, not just take questions, but also explain to people what the framework for the antitrust laws are and what the limits of antitrust are. I mean, Diane talked about the limits of antitrust, and that was talked about on the panel this morning. I think that's really important to understand what antitrust can and cannot accomplish. It's important for us. It's also important as we look outward to other jurisdictions in the way that they apply their antitrust laws. And I will say I'm kind of hopeful that we're never going to really have that problem here. I do remember around 2008 testifying on the Hill on a too big to fail hearing, and it was about why did antitrust forces let this happen? 2008. Why do we let that happen? And what are we going to do about these big banks that are too big to fail? And it was a diverse panel. It included Diana's predecessor, Burke 4, and I think there was someone from the Consumer Federation, myself, and someone else from the industry. And all of us said the same thing to Congress, which is you cannot expect antitrust to do everything. And while there may be legitimate concerns and too big to fail concerns and everything, antitrust does not provide the tools to get at that issue. And I think everybody, all the people the Congress people were sort of surprised and taken aback. But what was interesting to me is that was recognized across the whole panel, that antitrust was not the answer. And so I do think it's important to reinforce the limits of antitrust.
Commissioner?
I'll say just two brief things. The first is consistent with both what Diana said and Deb said. I think if you find something and you determine that it is the solution to every problem that you see, you're probably wrong in every context. And that certainly applies as well to antitrust. But thinking totally unrelated, Judge, you had a question to Diana about labor monopsony. And as I mentioned earlier, that's one of the things that we're going to look into. But I do want to note, to not a tremendous amount of fanfare, in 2016, the FTC and the DOJ put out human resources guidelines. And off of that has been built some of the very interesting enforcement that's going on right now at the DOJ of no poach agreements. Now, that's not necessarily what everyone is talking about when they talk about monopsony, but it is looking at labor markets, seeing how there can be conduct that can be anti-competitive, and when there is, going after it. It doesn't get a lot of fanfare, but it's really important. So just something out for which to look.
I like the way you don't end a sentence with a preposition, Joe.
My father always used to say, Noah, that's someone out with whom you'd like to hang.
Well, the no poaching issue did get a lot of notice in Silicon Valley, I think. Perhaps not so much locally here. Okay, we want to turn it over to the audience. Our objective was to do so at 2:10. By my reckoning, it's 2:15. We're not that far behind, and we'll run over a few minutes in order to accommodate questions. So please take your questions to the microphones that are made available for you there in the center aisle.
Back to you.
Questioning can work both ways. Most people who go to law school never sit in the front row again the rest of their lives, and here we are. Traumatized, are you? Yes, ma'am.
I have a question, just for the sake of asking a question, and I'm actually curious about this. I practice, my name is Monique Miles, and I practice labor and employment law in Virginia and D.C. There was a gentleman that had called me who was working in D.C., and he was in the IT field, and he'd signed some agreement, and he was telling me about Ninth Circuit anti-poach cases. Are you familiar with anything in the Fourth Circuit or in the D.C. Circuit that address those issues?
No. I should say not off the top of my head.
Other questions may elicit more longer answers, but it was an admirably short question.
I probably should have asked this question while the Assistant Attorney General was here, because it's kind of jumping off his speech where he first praised Bork's work on originalism and then his work in antitrust. And I realized I think this was like an entire conference sort of criticizing Bork for being an originalist on the Constitution and not on antitrust. But originalism and antitrust has been a big piece of sort of the hipster antitrust movement. They're saying we are going back to what John Sherman intended. We are going back to what the framers of this legislation intended by being concerned about labor, being concerned about bigness. And I'd be interested in what the panelists think about that.
Josh?
You've got the paper on this, Judge.
Well, it didn't deal with labor.
Didn't deal with labor. I will say the following. I've heard the same arguments and sometimes poked fun at them in reverse at some of the new critics of antitrust. Say, oh, you're originalist now. So it goes both ways for fun and entertainment. But I will say this: I don't have a particularly strong view on this debate. I mean, part of what's not in, at least it plays a small role in the paradox, and we don't talk about it much now, but one of the first scholarly debates that Judge Bork participated in was the big debate over how to read the legislative history on the Sherman Act, a debate that, Professor Land, among others, participated in. But that debate was one that he took quite seriously as a scholar. I mean, we tend to now that we view, by the time I got the book, I said this on the first panel, I was born the year it was published. So I didn't get to see much of the debate over the legislative history of the Sherman Act. My antitrust career, it's a settled question. We've got the consumer welfare standard. Now what do we do? But I suspect that what Judge Bork's answer would be is yes, the consumer welfare approach is perfectly consistent with a properly conducted sort of originalist view. Now, not outside of my area of expertise, but I would suspect that he would not be a big believer that there was a irreconcilable tension between his view as an originalist and his reading of the Sherman Act, which I think is sort of the wedge that the critics tried to drive. He answered that question. Whether he answered to the satisfaction of the critics, I'll pass on.
Well, you did read the article. Good. First of all, Judge Bork's treatment delved deeply into the legislative history. I'm not sure that he was or would be today so keen to look at legislative history, except for the fact that he was focused on this one statute and did everything he could to get to the bottom of things. It's a legislative history that is at best indeterminate, self-contradictory. Others have looked at it, Bob Land and Everett, his collaborator, and said, well, no, it's really meant to preserve firms and rivals, to protect rivals from anti-competitive conduct. Others have looked at it and said it's meant to preserve, I think it was, choice. But I think it's somewhat interesting that the courts have taken the consumer welfare lesson from Judge Bork and completely, literally ignored the two principal competing interpretations of the legislative history. They have not been, literally have not been mentioned. And I think the reason for that is that only the consumer welfare standard, at least among those alternatives put on the table, leads courts to determinate answers. And instead of conferring, as Josh said at the beginning, discretion to do most anything within some socioeconomic set of goals, or in the case of the other interpretations of the legislative history, not quite so broad a palette. That's one of the great virtues as far as courts are concerned, that the consumer welfare standard, it's something that is disciplined, that advocates can argue over and come to some fairly defined difference between them and let a court choose. And that's just not true with other standards. Anyone else on that?
The one thing I'd add to that is, as with any other question that we answer, it is really important that the conversation about originalism how it applies to antitrust law be a rigorous one. I don't think that it's enough to put up a cartoon of a trust from 18 whatever and say, see, it was meant to get at big companies. Dodd-Frank might have been meant to get at big companies. That doesn't make it an antitrust law. It's not. By the same token, although the timing is different from the Sherman Act or anything after it, there's a lot of talk about the views of the founders of the Republic about monopoly. And it's important when we have that discussion to understand what a monopoly was at that time, what that word meant. State charters of corporations that were chartered by the king or by others to do specific things, which is different from how we use that word today, whether rigorously or otherwise. So just to reiterate my earlier point, I think it's a very important discussion, but it's a discussion that has to be had with appropriate rigor.
I think it's a very good point. Originalism does not take us into legislative history so much as take us into what the words meant when they were used. And this is, unlike all the rest of the world except Canada, this is an antitrust law, not a competition charter. It was aimed at trusts, and what were trusts? They were disguised forms of cartels by which the corporate shares of competing firms would be put into a common trust, and therefore the rivals administered by a central intelligence. That was essentially a cartel. And that's what the trust was, and that's what I think monopoly is closest to when it was used. Anyone? So questions? Oh, yes. Okay. We have three competing questions coming.
Yeah,
Jane?
just very quickly to follow up on that last point for maybe if any other panels disagree. What is the role of intent as opposed to text? I mean, obviously, this is a classic thing in constitutional law, but also in this area. I mean, I refer a number of times to the intent of the legislation, but are you trying to do something other than just, well, here's what the legislation says, and here's therefore what it means, or are you trying to figure out what the legislators really wanted to do?
Josh, want to take a crack at that?
Not in particular.
Not particular. All right. Well, I can say, Gene, if I heard all the question, I'm not sure, but intent certainly plays a role when a court is trying to determine whether some conduct, say unilateral conduct, was anti-competitive in its purpose. All right. So, in looking at when conduct is ambiguous, this sometimes plays a role. So, if, for instance, something is done that, quote, makes no economic sense, close quote, apart from disabling a rival, that's a way in which intent figures into it.
If I could clarify, I don't mean that the intent of the person who's arguably violating antitrust is. Let me move to this. That might.
He's asking.
I don't mean that the intent of the person who's in violation isn't relevant. I mean, the question is how you're looking at the legislation itself. Are you trying to do a fairly traditional, here's what the text says and here's what it means, or there was, I thought, and maybe I misunderstood, some of the comments earlier were saying, well, we need to look at what the legislation intended to do.
Did you say legislators?
What the legislators intended to do,
Yeah.
As opposed to just.
Well, asking what the legislators intended to do, legislators being a plural, is very much like saying we have a headache. It makes no sense.
What I'm asking, I thought though, and maybe I was wrong. I thought there was an indication from a couple of the panelists that they were looking at something along those lines, and maybe I'm wrong.
I think the reason that happens in the antitrust context is that the text literally declares all contracts unlawful.
Yeah, I mean, that's
So you got to do something.
the Sherman Act is so broad, right? In a sense, I don't find it helpful to go look at to identify the intent. There were a lot of different intentions for the people, the legislators at the time. But what would happen is that, the Supreme Court very early on, to make this a statute that could be enforceable, said, well, it can't be everything, it has to be, and we injected reasonableness. And then, since then, the courts have given content to the law. But I believe that that's essentially what Congress meant. They said, there's a problem, go do something about it. And it was left to the courts to figure out, what is the unreasonable restraint of trade. And that's where you get these heuristic rules, and that's where we have the evolution to where we've gotten today. And I think it's not helpful to, at this point, go back and say, well, what was the original intent? Because whatever the original intent is, that there's a sense of what the law is now. It's unreasonable restraints of trade under Section 1 of the Sherman Act, and everything that we've done in the intervening years has been to try to say, well, how do we determine that? And that was, I think, the importance of the paradox, was looking at that question and looking at how people had given it interest and sort of suggesting a framework for going forward. And I think that's still a job that we have to do. Someone was asking earlier about sort of the heuristic rules, and one thing, for example, an area where we really need to get some more guidance, in my view, is in Section 2 enforcement, which we tried to do during the last Republican administration. We tried to have antitrust guidelines, these sort of rules, to make Section 2 more enforceable, more meaningful. Unfortunately, the effort to have joint guidelines with the DOJ and FTC failed because the FTC had issues with it, and I think they may have been concerned about the effect of the guidelines on some litigation or investigations they had pending. And then when the new administration came in, they sort of put it in the trash can or put it on the shelf. I think that's one area where we do need to bring it back. We need to bring back some effort to give some more definition to Section 2 of the Sherman Act.
Next question.
So this discussion has been properly centered on antitrust and Bork's work in that space. But Noah, as you mentioned, the Commission has asked a bunch of questions that also touch on consumer protection, especially privacy and data security. And in part, that's because the companies that have raised all the questions that people are concerned about their monopoly or quasi-monopoly power are big tech companies, and they also have raised a lot of concerns on the consumer protection and privacy side, which to my mind, so Bork gave us a good framework, the framework that everybody operates within for antitrust. We don't have anything near that in the privacy and data security space. There's not a framework that I think everybody agrees on what we're trying to achieve there. So this raises two questions for the panel. First, if it's the companies that are the issue and people are asking antitrust questions and privacy questions, why would that, do they really care about antitrust and privacy, or do they just care about these companies? And is that possibly driven by something such as competitors or something else that's not so much about antitrust or privacy, and something else, some third thing that's just using those tools? And the second question, are there things we can learn from Bork and the way that he established a framework in antitrust that we could transfer into the consumer protection space, where we could work towards a common language on what we're trying to accomplish in that space, particularly in the privacy and data security spaces?
I'll take a shot at the first part of the question and let somebody else handle the second part. So I think part of this debate over the ability of the antitrust laws to reach to modern competitive issues, embedded in there is obviously a dialogue about the platforms. There have been allegations made that the platforms are monopolists. I think that's kind of where it should stop before antitrust kicks into full gear and says, okay, well, we have methods, we have methodologies for determining how the platforms compete, whether they compete, what are our theories of potential competitive harm, what are potential remedies. For example, platforms could compete, technically in a differentiated platform ecosystem relevant market. I mean, I could come up with a relevant market that was defined around that, and I think you would see them competing Competing, absolutely, head-to-head competing in digital ad placement and targeting and all these kinds of things, social connectivity, information. That doesn't mean that there's no competitive issue there, but you have to start at some point, and that's in defining a market, right? Unless you've got direct effects of some concern. So embedded in there is the role of privacy and the role of data in how you deal with those issues in the context of antitrust. Those are not all antitrust problems. I mean, the privacy problem is not just an antitrust problem. I mean, I could give you a really good argument for why it's a good candidate for social regulation. I could give you a really good argument for why it's a candidate for economic regulation because of information asymmetries, right? I mean, that's the heart of the privacy problem. I could give you a really good argument as to how part of the privacy issue is an antitrust problem. And I think that the job of antitrust is to figure out where that fits in. So for example, mergers that hypothetically consolidate data processing capabilities, right? That could be defined as an asset, a line of commerce and a relevant market in a merger, and that should undergo antitrust scrutiny. Mergers that acquire, by the platforms that acquire edge competitors, potential entrants, that's absolutely within the reach and should be aggressively approached by antitrust enforcement. The use of data, cutting off access to data to foreclose rivals, that is potentially within in the wheelhouse of antitrust enforcement. But we should be careful not to jam the whole privacy issue into the antitrust bucket, because some of it is consumer protection, as you yourself have pointed out. Some of it is a competition problem, but we're increasingly seeing the nexus between competition and consumer protection. The use of deceptive methods, the use of data and privacy issues. We have a larger number of cases accumulating where deceptive methods, fraudulent practices, anything that falls within consumer protection potentially can be used as a competitive lever. And that's a good job for antitrust.
And on the second question?
I'll do a quick stab on the second question. I mean, the issue of why we haven't had what is the antitrust, the sort of Bork-led antitrust revolution in the consumer protection space is a thorny one, but I think it points out, I'm trying to think of all of the heads of the Bureau of Economics at the FTC who have walked in and said, this antitrust framework's pretty settled. Where I could really increase the rate of return? Let's get some more economics on the consumer protection side of the house, and left with their heads hung because it didn't happen. And my good friend and colleague, Bruce Kobayashi, is there now, and I suspect he will very much want to do this and hang his head on the way out like the 5 or 6 before him, but not for lack of effort or intellectual ability. And the reason I think that the struggle on the consumer protection side to have the same sort of revolution, which I think would be good for the world, kind of shows how special the antitrust revolution was. I mean, it was Bork and it was the antitrust paradox and an intellectual revolution in economics at the same time that he was using that came out through those particular individuals, but it was also the intellectual revolution happening at the same time. We haven't had, there's a big growth in intellectual energy in the privacy economic space, but it's just starting. We might be 10 years away, but you also had Reagan appointed a bunch of judges, right? It helped influence the law that were law and economics friendly, who helped move the law. You had private litigation. Most of the big revolution in antitrust cases wasn't the FTC and DOJ. It was vertical restraints, private litigation that helped move the law. It was GTE Sylvania, right? Monsanto, all that stuff, right? They moved all those cases, shifted the law, and that was mostly private litigation with government sort of coming in as amicus in some of the cases. You had agencies that bought into the revolution at the same time. You had heads of agencies like Judge Ginsburg, Rick Rule, who was here this morning, Bill Baxter, Jim Miller at the FTC, folks who were savvy about economics, cared about economics, had Miller was a PhD. All of that happening. I think you had a little bit of the perfect storm, and it was a perfect storm of which I certainly would say the primary cause was Bork. He was the catalyst of that storm, but it takes a lot of things happening together to get that sort of shift in the law. I mean, the antitrust doctrine shifted 180 degrees in a pretty short amount of time. You don't see that sort of revolution in other bodies of law hardly anywhere. And I think in consumer protection, you're missing some of those key elements. I don't think the intellectual revolution and the evidence is quite there, but we're working on it. I'm not sure if you have agency buy-in in the same way. You don't have the private litigation. 10 more lab MDs, and either the courts are going to have the revolution for the agency, or the agency is going to figure out they better do it themselves, right? But that's, we're not there yet, I don't think. But it does highlight, I think, how special of an intellectual event the paradox led on the antitrust side.
Glad you mentioned LabMD. That was my daughter's case before the FTC.
Can I just say, I wonder whether that means that Europe is going to be taking the charge in this. I mean, they seem to be a little bit ahead of the U.S., and I'm wondering whether they will basically set the table for how we end up going.
If ahead means bring more cases, yeah.
Yeah.
But I think if it means intellectual leadership.
Not intellectual, but in general, just establishing sort of a consensus outside the U.S. and sort of standards. I mean, given how international, how globally connected we are, it seems like they're going to be basically potentially setting the rules.
Well, the General Directive on Privacy Regulation is doing that right now. That's why we're all getting these emails from our apps saying, by the way, our privacy rules have changed. I'll get you in just a second, Dan. I want to throw out some. I want to throw out some red meat for you. I think this is privacy is a subject on which there's a need, Noah, for more precision in the use of the term, or maybe for two separate terms. In most contexts, outside of these apps and so on, networks, technologies, in most contexts, privacy just means people's desire to conceal something about themselves and just in deceiving others. Right? They don't want something about themselves known. But in this context, people are concerned about others competing to provide them with advertising that's more attuned to their interests. And people find that offensive. I don't, obviously, but I understand that a lot of people do. It's a really different interest altogether, it seems to me.
I think that's a great point. I think that privacy is a word that people earnestly use to describe a variety of different things. I mean, this morning, we learned a lot about privacy law in the United States that we didn't know before this morning, outside the context that we're discussing here, right, in the context of criminal law enforcement. But one of the things that I really hope, obviously privacy is going to be part, as I described before, of the discussion that the FTC hopes to inculcate. One of the burdens that we bear, although I hope it will be an asset for the conversation, is that when we talk about privacy, when we think about privacy, we are thinking about it in the context of enforcing consumer protection, and maybe, depending upon the circumstances, antitrust law. And so it can't be a conversation divorced from the practical realities that attend to each. The law, the economics that bear upon the law, the impact upon companies, upon innovation, upon consumers. These are all real. People, we bring cases. Sometimes we win, sometimes we lose. But when we have a conversation about privacy, one of my hopes is that we'll be able to ground it in part because we have to have that in our minds, or have all those things in our minds, structuring the conversation. What is the remedy? What is the legal test? What should be the rule? Those are important guardrails about how you have a conversation about privacy, for what that's worth.
I would close except for my sense that we had a question pending from the General Counsel of the FTC, Alden Abbott. So Alden, if you'll give us your question.
Well,
it was my understanding.
I was going to avoid your kind of invitation. I was just going to note that one of the things that Judge Bork famously wrote was greatest source, really, of barriers to entry and maintenance of anti-competitive conditions really was government action. Government-created entry barriers because they tend to be durable because they're backed by the force of law. And to what extent, Diana or anyone else, again, I'm speaking in my private capacity, just raising a question, to what extent is the burden of regulation, industry-specific regulation, whether in finance and in other sectors in recent years, perhaps created barriers to entry and disincentives to entry? And to what extent might regulation of that sort have contributed to slower rates of innovation in startups? So that's something outside the immediate antitrust enforcement system. That's something that might bear on such problems noted by Diana. Just something to think about, nothing more.
I think it's on your agenda for the hearings, is it not?
It's a big agenda.
Yes, okay. Well, with that, I want to point out that the October set of FTC hearings will take place locally here at the Scalia Law School at George Mason University in Arlington. I hope we'll have a lot of attendance there. I want to thank Federalist Society and Dean Reuter for bringing us all together. And I just want to say as a personal note that Bob Bork was a friend and colleague of mine, a very dear friend and colleague. I think he would have been quite pleased with the discussion today. Robert Jr. is here and can tell us whether that's acceptable. Okay, good. We have approval, vicarious approval from Bob Bork. So thank you, Dean. Thank you, Bob. Thank you, my colleague, Bob Bork.